Hey, come here. Let me tell you something. 91% of you all watching my videos aren't subscribed. Hit that subscribe button and like this video to receive enormous lump sums of generational wealth into your family's royal estate. To those still confused by the word citizen, thinking it hath but one meaning, there is a citizenship of the United States and a citizenship of the state. The court in Tashiro versus Jordan, 1927, made it plain there are two forms of citizenship, one national, one state. Yet the law never tells you how this duality binds you or how equity releases you. You've heard it your whole life. You're a citizen. But the question they never let you ask is, a citizen of what? In Tashiro versus Jordan, the court spoke openly that there is a citizenship of the United States and a citizenship of the state. Two different bodies, two different distinct allegiances, two jurisdictions, and you cannot serve both without confusion. Law would have you believe these roles are seamless, interchangeable, a single cloak worn the same way everywhere. But equity sees the stitching. It knows the difference between a garment woven by Congress and the inheritance woven into your bloodline. The law defines you as subject. Equity remembers you as heir. And the moment you grasp the distinction, the veil begins to lift. The record is clear. In Tashiro versus Jordan, the court did not blur the lines. It distinguished them. That there is a citizenship of the United States and a citizenship of the states. Two classes, two allegiances, two jurisdictions. The first, citizenship of the United States, is a creation of Congress, a statutory identity bound to federal oversight. The second, citizenship of a state, precedes it. It is organic, territorial, and sovereign in its recognition. Yet there lieth the confusion. Men of law would collapse these into one, binding heirs under the guise of subjects, treating beneficiaries as though they were mere corporate wards of the union. But equity will not suffer such collapse, for equity sees what law cannot. It discerns between the artificial person crafted by statute and the living heir entitled by trust. So I submit this: when they insist your only citizenship is federal, remind them that Congress itself can only confer what it created, not what was inherited. And the inheritance of the heir is not citizenship at all. It is dominion. It is birthright. It is equitable standing above and beyond the statutory class. Thus, the argument resolves: law may govern the citizen, but equity governs the heir. Hear this decree: the law may divide its citizens, federal and state, but equity divides not. Equity looks past both forms of citizenship and asks only one question: are you heir or are you not? For if you are heir, then no statutory citizenship binds you. No act of Congress defines you. No constitution limits you. Because the heir does not derive standing from law. The heir confers standing upon the law. Thus, veil removed. The citizen is subject. The heir is sovereign. The citizen pleads for recognition. The heir commands performance. And so I speak not to citizens today, but to heirs. Step forward as beneficiary. command the trust. For what equity restores to you, no government, federal or state, may ever take away from you.